everyone. Thank you for coming. I hope you're excited as I am to be in this lecture. So I will be talking about maximizing intellectual property for research. Kasi yesterday we've heard kung paano or the basics of intellectual property, no? And ngayon we want to make it a more practical approach. Kasi intellectual property honestly medyo mabigat siyang topic, no? So we want to make it really practical so that you can get to appreciate it more. Okay, so the topic again is maximizing intellectual property for research. And I am the co-founder, executive director, and director for intellectual property of the League of Innovation and Intellectual Property Advocates Philippines, a startup. Also, I'm a graduate again of UP College of Law, College of Engineering, Materials Engineering, and then UPIS batch 2009. So UP talaga tayo, homegrown. Okay. So sa aming startup, ang bati namin sa inyo, isang malikhaing araw sa inyong lahat. So kasi naniniwala kami na lahat tayo malikhain, no? Kahit nasa science ka, kahit nasa arts ka, lahat tayo may kanya-kanya tayong pagkakamalikhain. Kaya we encourage everyone, to become malikhain ourselves. Okay, just a brief background. So, sino ba kami? Sino ba si LIPAD PH? Sino ba itong in-invite ng NEC? Thank you for the invitation, by the way. So, we aim to develop a community of creators and innovators working to promote Filipino creativity and innovation. So, kasi kailangan mo maging creative eh. Otherwise, wala kang ipoprotect na intellectual property. Kaya, we want to package it, the entire package. We offer it, kumbaga, be innovative. At the same time, when you're being innovative, we encourage you to protect your IP rights. Kasi marami tayong horror stories, maraming kwento na, some Filipino talent pinatent nung tagalabas or nanakaw ng iba. So sayang naman yung pagiging creative natin and innovative kung hindi naman natin mapapakinabangan. Okay. And then our mission is to create an atmosphere conducive to the discussion and development of intellectual creations. And we want to be the go-to community of innovators for the protection and maximization of IP rights. So yung values namin, creativity, biggest, integrity, inclusivity, professionalism. Inclusivity, I would just like to highlight that also kasi although I'm from the sciences, I'm from engineering, my heart is with the arts as well. And intellectual property, as you might have witnessed in the lecture yesterday, it covers not only the arts, but also the sciences and everything in between. Kaya inclusivity. And we believe na malaking, kaya nga yung acronym namin is LIPAD, no? Because we want everyone, Capit Bisig, art sciences, working together to help bring the Philippines to greater heights. Okay, so we have IP-related discussions, knowledge transfers, community-centered programs and efforts. And then we also strive to create easy-to-understand tools. Kasi as you might have witnessed yesterday, very technical talaga. And today, we will try to digest it a little bit more para mas maintindihan pa natin yung intricacies ng intellectual property system without making your noses bleed. Okay, so we've had webinars. So the first webinar was to get to know patents, trademarks, and copyright, and then how to innovate for the better normal. And then, as I mentioned, inclusivity. We have a lawyer also on board. So nag-innovation naman kami in the legal profession. And then we discussed for the fourth industrial revolution. And then other lectures also we have done. Okay, so at this point, I would like to invite you to like and share our page, facebook.com/phlipad. So we have lots of content for you about innovation and intellectual property. And as mentioned earlier, we try to really make them more understandable to the audience. Okay, so again, we want to help bring the Filipino innovators to greater heights. All right, so what to expect for this session, no? We want to learn the correlation between research and intellectual property. We want to learn how the IP system can encourage access to information. We also want to avoid infringement. Ayaw natin yan, di ba? Kung gagamit ka ng patented or copyrighted information sa iyong research. And then, we will also be giving a little bit of resource links to help in your research. Okay. If you have questions, just type away. Oop, ayan. If you have questions, just type away. I can see the chat din naman. Okay. Oops. Nangyari. Okay. Sorry. Resume share. Nakikita niyo na ba yung screen ko dito? Okay. Sorry, nakikita niyo na ba yung screen ko? Hello? Naka-pause daw eh. Okay, thank you. Sige, so recap tayo from yesterday's topics. Yesterday, we learned the different kinds of intellectual property, the distinctions, invention patents, utility models, industrial designs, trade secrets, copyright, trademarks. And then ngayon, meron tayong slight recap ulit on intellectual property rights as exclusive rights and as rights, syempre, there's no right that is absolute. So may mga limitations din yan. Okay. So patents or utility models, they protect inventions. So isipin niyo na agad, ikahon nyo na. Pag sinabing invention, it's a technical solution of a problem in any field of human activity. So ikahon nyo na doon kasi if hindi na siya invention, yung tinutukoy natin, it might be another IP na. So patents or utility models may protect a product, a process, or an improvement of that product or process. So kung makikita nyo, pwede siyang building on innovation upon innovation. But at its core, patents or utility models can protect products or processes. Okay. Industrial designs naman, so kanina invention, ngayon designs. So a design is a special appearance to and can serve as a pattern for a product or handicraft. So pwede siyang line. So kung makikita niyo nasa kaliwa, it's textile. So pina-register yan nung isang grupo sa north, and so yung mga, di ba nag-weaving sila up north sa Apayao. So yun, textile Christmas stars, and then it could also be colors. So this very ubiquitous record book, apparently may industrial design pala. Gulat din ako na nakita ko eh. And even 3D forms, even cars, pwede sila because they're all cars, no? Pero every year meron kang bagong model ng car. Bakit mo and even if they function the same way, the appearance looks different. So that's what adds value to the product. Okay. Trademarks naman, they protect visible signs. So visible signs. Kanina, invention, then design. Ngayon, we're talking a visible sign. So yung nakikita. And the purpose is to distinguish the goods or services of an enterprise from another. For example, pwedeng word, pwedeng symbol, pwedeng composite mark, pwedeng slogan, pwedeng trademark yan, even the container. Because, for example, for pen shop, no, even if it's the same, or if it sells shirts, the only way it can distinguish itself from another enterprise that sells shirts, for example, bench, is with that word or pen shop or that logo. So yun yung function ng trademark, no? They help distinguish the goods or services of an enterprise from that of another. Okay. And then copyright, they protect literary and artistic work. So ikahon nyo na. Invention, patents, designs, industrial designs, visible signs to distinguish the goods or services, trademarks, and then copyright is for literary and artistic works. So anong kasama dito? Again, books, newspapers, lectures, artistic works. So dun sa performing arts, visual arts, meron din. Even scientific works like computer programs, etc. Because they can fall within that broad spectrum of literary and artistic works. So why do we need to distinguish the different kinds of IP? Kasi baka malito tayo, no? Sa isang produkto, pwede pa lang maraming intellectual property. Halimbawa, ito, backpack. So backpack lang. Anong pwede kong gawin sa backpack? Pwede kong gamitin, pwede kong ibenta, pwede kong tahian ng kung ano man. Pero there are different kinds of intellectual property pala in a bag. So yung zipper, that's patented. Even the branding, as I mentioned, it's to distinguish the goods or services of an enterprise from another. Even yung mga advertisement, the posters, ganyan, copyright, and the design of the bag is an industrial design. So isang gamit, maraming intellectual property. So, and as I mentioned, you need to compartmentalize kasi there is a tendency, I tell you, there's a tendency to confuse trademarks with copyrights, with patents. And people sometimes say na, what, ipa-trademark ko kaya yung patent ko? Mga ganon, yung invention ko. So, they're referring to different things and it might cause confusion to people. So, again, that's why it's important to be grounded dito sa distinctions of intellectual property. Okay. And then a different kind of IP is also trade secrets. So they protect information. I heard you talked about it yesterday, so I won't dwell into it. But these protect information, kaya nga secret, kaya siya valuable kasi secret eh. So that's why you have to make reasonable steps to make it secret. Okay, and it has commercial value because it is secret. So pwede siyang mag-cover ng know-how, even secret formulas, for example. And if you will notice, secret formulas, they could be patented, no? Kasi technical solution, kasi formula, right? So pwede tayong, pwedeng trade secret or patent yung kind of protection doon. But mamaya babalikan natin yan. Okay. So ano kinalaman ng intellectual property sa research? There's this definition from Hampshire College that I like, but I don't want to read this for you because you can read it perfectly. So what I did was to chop it down. So research is a process, according to the definition, involving systematic inquiry, use of existing knowledge, evaluation of hypothesis, and the creation of new knowledge. So kung gagawa natin siya ng proseso, it's like this. So it's like your scientific method, not defining the problem, and then you access available information, you use that information, tapos with that in mind, you do your hypothesis testing, and the result. There's always a result, diba? Whether good results or bad, a result is still a result. Okay, and this second set, no, access and use, these are what we call, diba, RRL. So when we do our thesis, it's the review-related literature. And papasok dito yung intellectual property. So let's focus first on access to background information. So ang tanong ko, where do you look for your RRL? When I did my thesis, hindi ko pa naisipan mag-Google Scholar nun. Pero ngayon may Google Scholar na. You can search for non-patent literature. I also use textbooks and past thesis. But syempre, tayong mga nasa engineering and sciences, hindi mawawala yung journal articles, di ba? So this is from the university library. So they have online subscriptions, international multidisciplinary, they have access for arts and humanities, management and economics, science and technology, engineering, social sciences, and law. So the whole spectrum, kumbaga lahat ng topics covered, meron kang journal article. And I guess maswerte tayo in a way sa UP because we have access. Meron lang DILNet account, we can get remote access. Pag enrolled, kaya, di ba? But what about the others who do not have that luxury, no? Or who have limited access to information? So totoo, that copyright can be used to limit access to information. I do not dispute that. And because it's perfectly within the rights of the IP owner, of the copyright owner. Pero hindi nangangahulugan na kailangan illegal yung pag-access natin. Diba? So like ito, kung may access tayo sa mga journals, make use of it. We don't need to go to that illegal piracy website. Kasi isipin nyo, no, kung halimbawa researchers, syempre researchers also own royalties from access to their researches. So, pag piniratan nyo yung access, paano na yung next set of researchers natin? Walang economic benefit. Okay. So notwithstanding that, there's what we call the open access movement, no? So it's a means to gain legitimate, free, and open online access to academic information. So, yung kanina, dun sa piracy website, syempre, lumalabag siya ng batas, yung nag-host, no? Pero dito, if it's open access, it's the copyright owners themselves who say na, oh sige, gamitin nyo to because we want to help in making information more available. So in that regard, we do not, or copyright is respected. Hindi siya na-violate. So, okay tayo lahat. Walang samaan ng loob kasi walang piracy. So, open access. So, anong example nun? So, according to openaccess.nl, it is actually, there's open access when there is no financial, legal, or technical barriers to accessing academic information. So, anyone can read it, download it, copy, distribute, print, search, etc. So, point ko, hindi kailangan illegal ang access natin. Kasi meron mga open access, mga legal access. Okay. So, they give an example. This is an example of a database of open access journals. So, they have 5 million article records, 15,000 journals. They could cover a broad variety of subjects, so agriculture, fine arts, etc. So, hindi lang science, pati arts. Okay, and even sa articles, no? Then si Elsevier, meron din silang open access journals. So, these are free. Again, you can use it. So, immediately free to access and download from Science Direct. Okay. I'm not promoting any of these companies, it's just that these are free, so you're free to use them. Okay, but I want to ask you actually, or I did a survey before. Tanong ko, have you used patent information as your research material? So I did a survey. I'm not sure if you can read it, but so the question is, are you aware? Number one, are you aware that you can use patent information to acquire information from the state of the art in a certain technology? And then as a follow-up, how often do you refer to patent documents? So, ang pinakamadaming sumagot is, I know patents. Maybe they've attended a lecture or seminar like yesterday. So I know of patents, but I've never consciously used them because my current resources are sufficient. So yung sinabi ko, textbooks, thesis, sufficient na. Meron naman nagsabi, I haven't heard and would like to know more. And there are some, so 12 yung nag-vote nung I know, but hindi ko ginagamit consciously. 3 yung gustong matuto. May 2 alam ang patents and they use them from time to time. And then, merong alam yung patents, but they might have considered using it, pero nakakalimutan lang. So yun. Medyo technical tayo ng konti. But I want to tell you that patent law has 3 purposes. So una, incentive. Incentive, syempre, patent law would want to foster and reward invention. Kasi if may invention ka, the way that incentives are given is through the giving of exclusive rights, no? Second purpose is disclosure. So, the patent law or patent system promotes the disclosure of inventions para naman may ibang taong makapag-build on that innovation. Pag nag-expire na, I mean, even during the patent's effectivity and after the effectivity, anyone can use it na. So, disclosure yung mahalaga doon. And then, finally, safeguard. So, the stringent requirements for patent protection. Kasi, as you learned yesterday, very strict ang patents. May mga requirements yan. So, yung strict requirements na yon, pag may hindi ka na-meet doon kahit isa lang, you cannot patent the innovation or invention, which means it's free for all to use. Okay? Sige. So, gawin natin a little bit graphical. So, there's this inventor. So, punta siya sa IPO. And para mag-apply ng patent. Apply, and then IPO grants it. But that is the macro level. But what happens what happens in a micro level. So what actually happened was that by giving a patent, the IPO grants exclusive rights to the inventor for a limited amount of time. Patents, 20 years. Utility model, 7 years, as you learned yesterday. Okay. Pero, syempre hindi pwedeng magbigay lang yung gobyerno ng incentive. 'Di ba? Kumbaga, isipin nyo na lang, tax yan. Syempre, the state provides a security sa mga benefits natin, SSS, even mga police, military protection. But anong kapalit nun? Tax. So ito, a similar analogy would be the disclosure. Yun yung mahalaga eh. So bibigyan kita ako si government, bigyan kita ng incentive, bigyan kita ng exclusive rights. Pero, ops, tell me how you worked it, how you made it work, or what the invention is. As I mentioned, kasi people can build on that invention. Okay? And then, the strict patenting requirements, they are being, kumbaga may checklist yung IPO basically. So dapat ma-check lahat ng requirements bago makapagbigay ng incentive. So tinitingnan yung disclosure, okay, na-meet ba ni disclosure itong patenting requirements? Pag na-meet, incentive. Okay? So that's how the threefold purpose of the patent law interplay with each other. But I want to focus on disclosure. Sabi ng batas, kailangan i-disclose in a manner sufficiently clear and complete for it to be carried out by a person having ordinary skills in the art. Breakdown natin because we are science people. Okay, first element, sufficient and clear disclosure. Pangalawa, kailangan mo ng person having ordinary skills in the art. Okay. So this is an example of a disclosure. We just took it from a patent document. So actually, this is produkto din to ng UP Engineering. But a part of that patent document is the disclosure of the invention. So sinabi nila dito, the benefits of the invention are, etc., etc. And mamaya we'll dig deeper into what the patent document can offer. Okay. Ano yung sabi ng batas na a person having ordinary skills in the art? So it's an ordinary practitioner who is aware of what common general knowledge in the art is. So may mga presumptions tayo dyan. So alam niya lahat ng references doon with respect to that relevant art. Alam din niya lahat ng mga relevant art in relation to that particular problem. So it's your general practitioner talaga. And meron din siyang capacity to do routine work and experimentation. So it's basically us, di ba? Or yung mga graduate ng engineering who do practice. Okay. Kasi we have all these references and arts at our ready disposal. Okay. So, balik sa diagram kanina, papasok si person skilled in the art dito, doon sa requirements that, the stringent requirements, di ba? Kasi, yun yung lente na tinitingnan. Because at the filing date, again, si person skilled in the art, siya ordinary practitioner mo. And in relation to a patent document, dapat bago yung invention mo. Otherwise, if alam na yan ni person skilled in the art, hindi na siya mapapatent. Because it's common knowledge. Or kahit hindi man common, basta alam doon sa circles nila. Also, to the person skilled in the art, that invention is not obvious to him or her. Kaya nga, kailangan mo ng, this is a requirement for patentability, no? And actually, these two requirements, novelty or non-obviousness, is what is important actually to find out when we use patent information. Because this can be an important source of knowledge for researchers and inventors. Kasi ayaw nating umulit ng thesis, basically, di ba? Ayaw nating umulit ng R&D. Sayang sa pera, sayang sa effort. Also, syempre gusto natin malaman kung patentable yung inventions. And then, we want to learn or we want to know or to be able to exploit technologies from patent applications na never na-grant. Kasi, diba, as I said, pag hindi na-meet yung requirements for patentability, yung strict requirements, yung embudo kanina, hindi siya mag-grant, meaning anyone can use it na. Okay. Kung hindi rin valid yung technology, kasi patenting actually is territorial. When you file your patent here, it's protected only here and not everywhere else. So you have to file for a patent in each and every country, and there are mechanisms to facilitate that. Okay. And then expired patents, syempre, pag tapos na yung protection, anyone can use it. As I mentioned kanina, di ba, doon sa threefold purpose ng patent system. Okay. So patent information is also important, lalo sa atin that we might be doing or dealing in policy work, because nakikita natin anong mga fields na ang interest natin. So for example, DOST has an agenda, di ba? Research agenda. So pwedeng ipasok itong ganito eh. Tingnan natin, okay. Mamaya, we'll be showing an example. Okay. So what's best about patent information is we can look for it for free. Okay. Mamaya I will be giving out links. Okay. So example lang, no? Ako, gusto ko kunwari thesis or research topic ay gusto ko magkaroon ng coating na may very low reflectivity. So okay. Yun ang definition ko ng problem. So ano kayong concepts na related doon? Okay, coating or low reflectivity, optics. Kasi reflectivity yung binanggit. And then maybe color. Maybe pag closer to black, low reflectivity. And then we're talking coating or thin films. Alright, so punta tayo kay Mr. Google, ganyan, coating low reflectivity. May resulta naman, scholarly articles, ganyan. Wikipedia comes out first, ganyan. In Google Scholar, meron din mga specific na meron din mga journal articles na lumalabas. And when we look at our favorite journal websites, Science Direct, meron din naman siyang outputs, but the most relevant, yung top na lumabas is low reflectivity amorphous carbon-based thin films employed as anti-reflective coatings. Okay. Maybe hindi pa yun yung specific na hinahanap ko na prior art, but I have to still scour through the entire database. Okay. Pero punta ako sa WIPO IP portal, and then sinearch ko lang coating very low reflectivity. As in, ganun lang kabroad. And then lumabas. Top. Low reflectivity coating and method and system for coating a substrate. So parang, parang ito yung interest ko. Puntahan. Okay. So looking at the applicant, nakalagay Surrey Nanosystems Limited. So Google tayo. Okay. It appears that invention is called Vanta Black. So Vanta Black, trademark, but the coating technology patent. Magkaibang IP in one object. Okay. So, sabi nung search ko sa Google, Vanta Black swallows everything it's painted on. Interesting. So, nawawala yung, ito siya, coating. So, para lang siyang flat na circle, no? Yung nawawala yung contours ng mga objects. It's it's hydrophobic. Nawala yung details ng car. Okay. This one is a foil, tapos nawala na yung contours ng foil. Ito painted on painted on an object na it's the same thing. Pinint lang. Ayan. And ngayon, doing a little bit more research with Surrey Nanosystems doon sa WIPO patent scope. Meron na silang bago ngayon. So kanina coating, ngayon pintura na. Paint with low light reflectivity. So yun na yung improvement nila sa existing invention. Okay? Sige. So, contents of a patent document, we can see bibliographic data, we can see the application date, we can see a drawing, title and drawing. We can see also the grant date, and then meron ding abstract. Meron ding other patent publications. We have the name of the applicants and the inventors. Nababasa nyo ba? Or no? And then classification, there's what we call the, teka lang, let me just reshare my screen. Hopefully, mas makita nyo ng maayos. Teka lang, sorry. Share screen. All right. Ayan. Ayan. Okay na, I hope it's better. Sige. So, as I mentioned kanina, so classification, no? There's what we call the classification, the IPC, the International Patent Classification. And then there's also the CPC. Kasi it's another kind of classification that is being used. So kung titingnan natin yung IPC, yung unang IPC is C03C1742. So pwede nating himay-himayin yan eh. C is the biggest classification. So if nakita mo C yung start, it's a chemistry invention. It's a chemistry-related invention. Then the numbers and the succeeding letters, they just narrow down the classification. Okay. And then we also see a description of the invention. So technical field, the background, the summary. So basically what the invention tries to solve. And then this is the important part, the claims. The claims, they tell you or they tell the people, ano ba yung binabakuran ko? Alin bang invention, alin specific invention yung binabakuran ko, which I claim to be mine. Okay. So pag nag-grant yung claims, that is yours for 20 years. Syempre may requirements tayo ng maintenance, but point is you can exercise exclusive rights over the subject matter of your claims as long as the patent is subsisting. Okay. For Vanta Black, there's 7, 26, 33 claims just for that invention. So makikita nyo na more or less saan ba yung sakop niya, so that when you try to innovate or improve on this invention, alam nyo na kung, okay, alin yung nagpo-fall squarely doon sa kanyang claims, alin yung labas doon sa bakod, which you can fence for yourself. Okay, I hope that makes sense. Okay. So, there's also drawings and then graphs, naglagay sila. So getting started, visit your free databases, patentscope.wipo, patents.google, lens.org. And then key information you might need, I mentioned them earlier. So keywords, patent classification, dates, etc., etc. So patents.google, IPO Phil, pwede ka rin mag-search. Kanina, WIPO, patent scope. So ito, global. Yung kanina IPO Phil, it's just Philippines. Then there's ASEAN patent scope. And then the lens.org, this is a free database. And what I like about this is, kung titingnan nyo sa kaliwa, merong ito, patents. Nakalagay na dyan, applications, jurisdiction. So pwede nyo nang i-refine yung search. Also, dito sa side na to, there's open access. So open access scholarly works you can access through that website. Okay. And moving forward, so we've talked about patent information. We now go to patent landscape reports. So imagine, inaggregate nyo na lahat ng mga patent information into a report. So this gives a snapshot of the patent situation of a given technology, pwedeng country lang, region, or globally. And then it has far-reaching implications, especially sa policy making. So ito, example dito, water desalination. And sabi dyan na the integration of renewable energy sources can lead to a decrease in cost and carbon footprint. So yan yung kanyang conclusion, kumbaga, from doing all of the report. So another example, e-waste recycling. Ang description dito is that the search in patenting activity points strongly to the commoditization of e-waste as a source of high-value materials. So ito yung technology trends. Recovery of platinum, recovery of gold, of silver, etc. And then you see the spike in patenting bandang 2000s na. Okay, makikita nyo rin sa patent landscape reports, top applicants, for example, dito, Panasonic, And then countries, top filings. So Japan, yun leading. And then pwede ka rin magkaroon ng conclusion about, okay, sa developed economies, anong klaseng specialization ng mga patents yun nandun. Yan. So you can check out WIPO. So meron silang mga patent landscape. It's usually, it's global yung kanila. They have different categories, topics. And then there are also patent landscape reports by other organizations. So ngayon, artificial intelligence, yung hit. And then gumawa yung Brazil, yung Canada, UK, etc. Okay. So the use of information naman. So kanina access, we talked access. Ngayon, the use. Kailan pa mong pag-usapan dito? Use of information? Actually, meron. Kasi first, I would like to point out na walang copyright sa idea, procedure, concept, news of the day, official text, works of the government made by a government employee in the course of regularly prescribed duties. And since wala kang copyright, they're free for all to use. So you can use any idea, for example, the concept of making a low reflectivity coating. But if once I put that in writing, once I make a report out of it, that report meron siyang copyright. So yung idea wala, but my expression of that concept, that idea, is protected na. So yun yung sakop ng copyright ko, but itong mga to, the idea, they're free for all to use. Okay, but where there is protectable intellectual property, the law grants exclusive rights to the IP owner. So pag produkto, kung titingnan nyo yung may read, restrain, prohibit, or prevent. Under the law, I would like to point out that the law for patents says na you have the right as patentee to restrain, prohibit, or prevent. Restrain, prohibit, or prevent lang. Compare that with copyright. Yung kabila, yung merong, okay, you may carry out the acts. So patents are very exclusionary rights, negative, only prevent. Bakit? Kasi when we are talking inventions, again, kanina, nakakita tayo ng example ng innovation upon innovation, no? So, pag ganun yung nangyayari, yung pinaka-naunang invention, the later ones, they have to ask for permission dito sa nauna because they are building on this first invention. So kaya, to restrain, prohibit, or prevent. Copyright naman, mas maluwag ng konti. Carry out, authorize, or prevent. But, common to all of them, no? Yung use of information, they are, the patent rights and copyright affect the use of the information somewhat. Okay? So, but then, as I mentioned, wala namang right na absolute. So, there are limitations to rights, fortunately, that may be applicable for research. So, pag sinabi nating limitation to right, okay, hindi na natin kailangan magpaalam, pwede natin gamitin yung information kahit hindi na magpaalam. So, eto, under the law, under the Intellectual Property Code, if you make or use exclusively for experiment, for scientific purposes or educational purposes, then that's fine. You can do that even if it's patented. Remember kanina I said it's if you use the product in general or the process or the product obtained from the process, you cannot use those protected subject matter. Pero ito, even if protected siya, as long as you're making it for your experimental use, thesis for example, so for scientific purposes or educational purposes, that's allowable. So hindi kayo pwedeng habulin ng patentee. Batas na yung nagsasabi niyan. On the other hand, copyright naman, making of quotations from a published work. We know this, very basic, but sabi ng batas, you can make quotations from a published work if compatible with fair use and only to the extent justified for the purpose. So ang requirement doon, cite the source and name of author. Sounds familiar, no? This is something that has been taught to us since bata pa tayo. Cite, do not plagiarize. Okay. And then fair use. I don't want to go into this very deeply, pero very generally, fair use for scholarship or research is allowed. It's not infringement. And there are certain factors that are taken into consideration, so case-to-case basis, to determine whether or not use is fair or not. Okay? Pero hindi ko na pupuntahan yan. But this is the list under the law. Sa isang banda naman, Sa isang banda, moral rights naman, so these are independent of copyright. So copyright, yung sinabi ko kanina, these allow the author to derive financial gain. So anong acts yun that allow the author to derive financial gain? It's the right to reproduction, to sell, etc. Yung kaninang nakalista. On the other hand, moral rights naman, so financial gain sa copyright, moral rights, they highlight the personal link. Moral eh. It's between you and your work. Bakit? Kasi even if, for example, we write about Romeo and Juliet, it's the same concept, pero our experiences, yung mga sarili nating hugot, no? Kanya-kanya tayo. So meron tayong different take on that concept of Romeo and Juliet. Yun. So, and that is our personal link to the work. So kasama doon sa moral rights ay yung right to be attributed as the author. So this is plagiarism basically, di ba? If you do not attribute, that's plagiarism, at least in an academic setting. But this kind of non-attribution actually makes a person liable under the law. Kasi the author has the right to be attributed, so you need to cite them perpetually. Sabi ng batas, perpetual. Pero mapapaisip na lang tayo, no? Kung perpetual yung requirement of attribution, sino mag-enforce? So, I don't know. But at the end of the day, that is the law. And under the law says that we have to attribute. Okay. Next is, hypothesis testing and then result. So the result could be paper output or a product or a process. So si paper output, ito naman, medyo nag-reverse na tayo. Dahil tayo na yung gumawa ng sariling intellectual property, ito naman, it can be protected by copyright. So under the law, copyright is vested from the moment of creation. And then, yung ownership ng copyright would depend on the circumstances surrounding the creation of the output. So kung empleyado ka ng private company, kung empleyado ka ng gobyerno, if kinommission ka lang to do a paper or research, so the rules are different. It's under the law. It's indicated in the law, and we will not go into that deeply. Pero even if may protection ka na ng copyright, no, if you are citing or if you're using other sources or other authors, respect moral rights. Ayun, so doon pumapasok yung copyright. Kung produkto naman or proseso, pwedeng patents or or industrial design. As I mentioned, product, di ba, or process, technical solution. So, kailangan mo naman mag-file ng application dito. And patent ownership depends on the circumstances surrounding the creation. So, ganun din. Kung empleyado ka, kung trabaho mo talagang gumawa ng inventions, kung hinire ka lang, etc., etc. Okay. But post-research, no? Patapos na tayo. Post-research, kung may paper output ka, anong usual na ginagawa natin? Okay, publish or present. Surprisingly or not, may copyright din yan yung presentations natin. Kung produkto, you can choose to license it out or sell it to a third party. Or ikaw mismo, gusto mo gumawa ng company around that product or process and create a spin-off. So, dito papasok naman yung other IP. So, trademarks can protect the name of the company, the technology. So, kanina, di ba, Vanta Black, Surrey Nanosystems. Names, but they pertain to that technology of very low reflectivity. Okay. Papasok din dito, syempre, yung gamit ng other intellectual properties such as trade secrets, copyright, etc. Okay. And an important point I would like to make is before you go all of that, before you publish, before you present, before you license or create a spin-off, you file your patent. Bakit? Kasi especially if your paper is talking about something that may be patentable. Remember I mentioned earlier, novelty, no? To the person skilled in the art, kailangan bago. Ngayon, kung present mo na sa conference where that person skilled in the art is, hindi na siya bago. So, madadali ka sa patentability. No? Especially if you want to go outside of the Philippines, mahihirapan ka magpapatent. Likely, marireject yan. So, ito natin sa Philippines, meron tayong tinatawag na non-prejudicial disclosure in the sense that if the inventor himself or herself discloses the invention, you have 1 year to file for patent here in the Philippines. Pero Pilipinas yun. In other countries, wala silang non-prejudicial disclosure or walang grace period, so to speak. So, yari na yung invention mo, especially if you want to go abroad. All right. So, what we learned from this session is that we learned the correlation about research and IP, and then how the IP system can encourage access. No? Access to information, again, yung patent system, the disclosure, and then the disclosure function of patents, and then the patent documents, patent landscape reports. And then how to avoid infringement in using patented or copyrighted information. So, as I mentioned kanina, the limitations, di ba? Purely experimental use, pwede. Citing works in your own work, pwede rin. As long as you mention kung sino yung pinanggalingan. And then we've talked about resources to help in your research. So we have WIPO Patent Scope, IPO Phil, The Lens, Google Patents, Google Scholar, etc. Also DOAJ, Directory of Open Access Journals. So these things can help us in our research. And surprisingly, intellectual property is not violated. I mean, with that framework, no? Kasi, to be honest, before, I would consider din yung going to Sci-Hub, ganyan. Pero, syempre, we want to do it the right way. Especially, we're an academic institution, so we should do it the right way.